Assalamu alaikum everyone. My name is Mustafa Yar Hiraj. I serve as the president of the LSESU Pakistan Development Society, and it is with distinct honor that I welcome you all to the third and final session of the LSE Future of Pakistan Conference 2023, a conversation with the Honourable Mrs. Justice Ayesha A. Malik. As I'm sure you all know, throughout Pakistan's history, the judiciary has played an important role in shaping the legal and political systems of the country. As you heard from the first panel today, sometimes at the expense of civilian governments through legal principles such as the doctrine of necessity. If we consider the judiciary of today, it has now emerged as a power player in Pakistan. In its own right, given the expansive use of suo motu powers and perhaps more importantly, the resolution of political controversies such as the vote of no confidence, as well as the disqualification of elected prime ministers. This session presents a unique opportunity in the shape of a discussion in which a distinguished jurist may directly address elements of both progress and imperfections within the judiciary in Pakistan, as well as looking at the way forward. Our moderator for today's session, Dr. Darr, is a lecturer in competition law at the University of Manchester and a senior research fellow at the UCL Center for Law, Economics and Society. She completed her PhD from UCL Law in 2018, in which she compared the adoption of competition laws in India and Pakistan and demonstrated the impact of the adoption process on the quality of competition enforcement in the two jurisdictions. Dr. Darr is also a barrister of Lincoln's Inn and an advocate of the Supreme Court of Pakistan. Prior to embarking on her academic career, she practiced law in Pakistan. She has served as the head of the legal department of the SECP and was the first and only female partner in the firms of Heather Mota & Co. in Karachi and ABS & Co. in Islamabad. Dr. Darr has also written on competition law issues in leading international publications and has regularly contributed op-ed pieces on a wide range of legal issues in the Dawn. Dr. Darr's monograph, Competition Law in South Asia, Diffusion and Transfer, was published by Cambridge University Press this past month. Before we begin the session, I would like to take the opportunity to highlight a few specific rules and regulations which are in effect throughout the duration of the session. First and foremost, no sharp objects, nationalistic and political symbols, such as flags and banners, are allowed inside the venue. If these are found to be in your possession, they may be confiscated. Furthermore, I would just like to clarify that no photography or audio-video recordings of any sort are allowed during the session. Without further ado, over to Dr. Darr to introduce our esteemed speaker for this session and get proceedings underway.
Thank you, Mustafa. Assalamu alaikum, everyone. It's a great pleasure for me to be here. Always good to be back at the LSE. But really, the excitement today is to be in conversation with Justice Mrs. Ayesha Malik. As you all know, she was appointed as a judge of the Supreme Court of Pakistan in January 2022, a momentous moment for all of us, myself included, who have practiced in Pakistan as women lawyers, to have one of our own represent us at the bench. So truly, a wonderful occasion for me to be in conversation with her. Before I introduce her more formally, I'd just like to say I have known Ayesha as my senior at Fakhruddin G. Ibrahim, where she was a senior associate, and also we share in common Rizvi Isa and Co. Unka naam badalta rehta, so I keep forgetting what their name. But Ria, she was a partner over there, but I had also been an associate at some point. So if you think we're being a bit informal and friendly, there is a reason for that, because I have known her personally. But going back to Ayesha, she has a very eclectic education in her youth. She studied in Paris, New York, and also completed her A-levels from London at the Francis Holland School, which you can, near the London Business School, if you walk by, you will see it. And she did her A-levels from the Karachi Grammar School, which was in Karachi. Another thing we have in common, we also were there together. She did her BCom from the Commerce College, Karachi, did law from Pakistan College of Law, and did her LLM from Harvard Law, where she was honored as the London H. Gammon Fellow in 1998-1999. As I mentioned, she has been with Fakhruddin G. Ibrahim for several years, and she was a senior associate there. And then she moved on to Rizvi Isa, where she started as an associate, but then was a partner from 2004 onwards. And she was appointed as a judge of the Lahore High Court in 2012. As a judge at the Lahore High Court, you can already see that her patterns were getting set. Her thought process, rather, was becoming evident. She was the president of the Protection of Women Judges in the Lahore High Court, which was a special committee formed to safeguard the female judges in the court. She was also a member of the she is rather, continues to be a member of the International Association of Women Judges, and she has also served as the chairperson of Judicial Officers' Female Supervisory Committees. So a long and distinguished career, and today we will try to unpack bits of it so that we can also learn from it and be inspired by it. So thank you, Ayesha, for being here and for being in conversation.
Thank you for having me here, and Assalamu alaikum, everyone.
So let's begin. I would like to just start by reflecting on your professional journey. You know, we all have a sense that being a female lawyer is at least an interesting career choice. How would you define your journey, and how has being a female shaped it? What were the limitations you faced? And we talk a lot about limitations, but what were also the advantages that you think may have, you know, the special opportunities that you feel may have come to you for being a female?
So my journey, I believe, I would say, is one of challenges and opportunities. Many challenges along the way. As you mentioned, I was the only female associate in the law firm, the only female partner in the law firm, the only judge in the High Court for over a year and a half, after which another judge was appointed, and the only female judge in the Supreme Court. So imagine this hall full of people, and imagine if this was full of all men and there was just one woman in the room. That's the feeling you get when you're the only one there. So that's the challenge, and with the challenge there are a lot of issues, from, you know, where are the bathrooms, to how people address you, to where you should sit, how you should dress, and even to the conversation at tea time. You know, it's very locker room conversation, boy talk, and you want to kind of say that the conversation has to change now because I'm in the room, and I don't really relate very well to the boy talk, so that should change. For me, this is important because I believe I've led a good life. I've come from a background where I've been lucky. But for the women in the district judiciary, it's not so lucky. They have a different background. They have a tough life, and the crowd that they have to deal with is also tough. So when you think about those women, and you think about those women being lesser in number, then you think about the fact that the courtrooms are not really built for women, you have to really think, what is this journey all about? And as the years have gone by, I believe that it's all about the gender perspective. That's what I'm about.
Okay.
I think our system misses the gender perspective. We don't have a gender perspective in our system. And I think this is what my calling is all about now.
Now, that's extremely, I think you've expressed that calling throughout the choices you make. But you also mentioned when you started answering, you said it's full of challenges and opportunities. So before we get into the gender perspective, because I really want to talk a lot about it, could you tell us a little bit about the opportunities that you think have come your way, and that you were able to take them perhaps because you were not bound by the very strict career path that men feel they have to follow?
Well, no, I wouldn't say that it's not about following a strict career path. I think as a woman, I had to work harder. I had to always sort of be on my best in order to show that I'm capable, and in order for people to have trust in me and have faith in me. But I think that the opportunities, basically as chairing the Commission for Women, as leading women delegations to conferences, gave me an opportunity to put forward the issues of these women judges. So during my time in the High Court, we hosted 3 women judges conferences, where we got women judges in the room and we asked them to talk about their issues, to talk about their role as women judges, to see what difference they can make. So 3 successive conversations, starting from the issues of the judges themselves all the way to the path that these judges can lead and how they can make a difference and make an impact. I think that's also very important. And these are the opportunities you get, I guess, for being the only one there.
So, would you say it's a lonely path, or have you found allies along the way, male or female?
Not a lonely path. I have lots of allies, male and female. But again, it's difficult to explain, because you have a mindset, you have a narrative that is already in the system, and you're constantly battling that narrative. And I explain it by saying that it's a country where the laws and the policies are made by men. They're interpreted by men. And it's the men who basically tell you how the women have to respond. It's the men who tell you how, what the experiences of women are. So there's no women injecting their stories, their viewpoints. And so that narrative is missing. And that's where the challenge is, because you're often told, this is the way we do things. And then I would often say, but why should I do it like this? That's not how I do it. And so then that's sort of, where the game begins and where the opportunity is created, where you have to create a new narrative for yourself.
Okay, so let's unpack that a little bit. How do you feel that your gender perspective has allowed you to recognize biases that are not obvious to men? I know we've had a conversation, and you mentioned the way judges behave towards women litigants or lawyers or even towards children. So please tell us a little bit about that, and then I'll unpack this a bit more with you.
So the gender perspective as a woman on the bench means that you look at the issue before you from the woman's point of view. So I had a case where women who were in the counterterrorism squad, they applied to work for that force, but they were not given jobs in the field because the department said that women should not be in the field. We don't want these women running around with guns, and we don't think that that's the place for them to be. They challenged this and said, we're high on merit, we're better than everybody else, why shouldn't we be there? Now, the gender perspective allows me to hear that bias, allows me to hear the discrimination, and as a woman, I can relate to it as well. And so the judgment talks about stereotype and barriers and cultural sort of mindsets of defined roles, and says that that's not how it works. These are women who've crossed that barrier. They're good on the merit. They should be allowed to do what they feel they want to do. And that's really what the gender perspective is about creating space for women, allowing them to lead the life they want to lead without having to constantly defend themselves. And the gender perspective is also about acceptability. So in my courtroom, very often, people would wonder, does she understand? Does she even see what I'm trying to say because she's a woman? And I've had people say that to me, that madam, maybe you won't understand it because you've actually never been here or never done this, so you don't know what I'm talking about. And my question would be that how many of the other judges have gone there and done that and seen that for them to understand it better? So why don't you just explain it to me? I often enough said, you can draw it for me if you think that I don't understand it, but I will understand. And I think that over the years, one of the best compliments I've gotten as a judge is that I'm the best male judge on the bench. So I take that as a compliment, because I think what it means is that I'm good at what I do.
I've been in a courtroom that Justice Ayesha was presiding over. And it was the only moment, it was just before I was leaving for my PhD, and it was the only moment where I thought, I wish I wasn't going, because, I could follow in her footsteps. But I had an admission and I did leave. But she was absolutely fantastic, the way she controlled, really rough characters. Lawyers are rough characters. But that also reminds me of another very important issue that you alluded to in your earlier response. You said something about bathrooms and toilets. Now, I think a lot of young prospective lawyers don't know this, that well, you know that we need access to toilets, you know that. But what you don't know is the courtrooms don't make it easy for women. So if you can tell us a little bit about that, and how I could tell them, but I wanted to come from you, yes, and what you have done to support women, both in the staff and litigants, and you as the lone judge, but how can we support women to be more comfortable in this regard?
So there are structural problems, because like I said, it's been designed by men for men. So nobody's really thought about women working in the buildings as lawyers, even as litigants. Surprisingly, even for women litigants, there's no safe space where they can sit, where they can nurse their children, where they can remove their hijab and just be comfortable. Nobody's really thought about it. So one of the things I do is really talk a lot about this, and try and encourage the women judges in the district judiciary to create those safe spaces for the female litigants. It also means for the lawyers, there are no bathrooms really for women, and those have to be built into the structure. So there's a lot of conversation about it, and recently I've been advocating about it so that there's a budget so that we can actually have women toilets in the courtroom. I mean, it sounds so primitive, but just imagine in this huge big university campus of yours, if there was just one toilet for women and you'd have to walk a good 20 minutes to get to the toilet. So it's not comfortable at all. Then many of the women judges don't have chambers in the district judiciary. So I also think that they need common rooms where they can sit as women in a safe space and, you know, just be the way they want to be. So this conversation often brings up the conversation, but why just for women? Why not for men? And I think the answer to that is because the women need their own space. I mean, I don't think there's any debate on that. And then the other problem with this is that we can't detach from ourselves who we are as people and what our mindset is. And there are cultural and other reasons why we want to make sure that if women are coming to the courts, access means that they are comfortable in that environment. And something that happened with us, we had visitors from the IAWJ, so women judges from around the world came to visit us in Pakistan, and we took them to court. And it was interesting to see how these women judges walked into the courtroom and noticed 2-3 things that they thought right off was wrong in the courtroom, and came out to say, you know, you're the accused and the victim in cases where there are men and women are too close together, and the distance from the judge is also too close. So why don't you do these things to kind of like manage your courts more efficiently? I think that makes a big difference. And that also alerted me to the fact that I can also make a difference. So like in my court, if there are family cases, I would hear them in the end and not in the beginning when the courtroom is full, or if the case pertains to a sensitive matter, which I think is personal and private, I would listen to it in the end when my courtroom would be empty, just to protect the privacy and the dignity of the litigant before me. I could do it in a full courtroom, but my idea was that I want to keep the environment comfortable and safe. For lawyers also, when they would stand at the rostrum, I would often just sit there and wait, and the lawyers would be looking at me that, what is she waiting for? And the idea was that, you know, give space to her. Don't sort of cluster around her. Give her space to breathe so that she can argue her case properly. So with time, people have worked on this and have figured out that there are things that need to be done. We have a long way to go, but I think we're on the right track.
So I think what this shows is that when, you know, we talk about access to justice, it's not just about ADB programs and money at the top and for big programs, but really at the very grassroots level, we want to make people comfortable, and that's where Justice Malik is also focusing her attention. So that leads me to the next question. I was actually listening to your interview for the International Women's Day last year, and you know, I'm going to paraphrase very badly because I will not quote the whole thing. But one of the essence of that interview was that you felt that your gender, your sensitivities as a woman, as a woman who's occupied many roles, as a daughter, as a wife, as a mother, you know, you bring those sensitivities to your judicial decision-making process. And I mean, you saw it, as I could sense you saw those characteristics as enabling you. But I want to ask you a little, you know, sort of the opposite question, that is there also a limitation in the sense of how far can you go to support women? I mean, what can we do when the law as it's written is not supportive of women? I mean, where are we drawing the balance? Because one of the critiques we hear about women in all spheres of life is that we are emotional, or we are empathetic, and we're going to operate out of that space. So I mean, how are you, if at all, how do you think about it, and how are you balancing that? Yeah.
So one of the things I was told when I became a judge, which is quite interesting actually, is that judges are gender neutral. And I thought, up until now, when they were all men, they were not gender neutral. And now that I've entered the picture, suddenly we become gender neutral. So that's what got me thinking that why are we supposed to be gender neutral? We're not gender neutral. Historically, you didn't see a lot of women in the justice sector, certainly not as judges. But today, there are many women as judges, as lawyers, prosecutors, police women. You see them all, they're there, they're working there. So there is a whole new set of experiences, there's a whole new set of thinking that has entered this domain. And that's what the gender perspective is. The gender perspective is when you bring this new experience, these new thinking processes into the system, and you include it as part of the system. Simply putting women there does not mean inclusion and diversity. Inclusion is real-time inclusion, which means that the narrative has to change. And we have to reboot our system now. We have to rethink it. We have to re-look at policies because women have not been part of the decision-making. And that's where women judges have a role to play because they help build a new narrative in their judgments. They look at issues again and they can rethink the way these issues should be looked at, the way the law is working. And I can give a few examples to show how the gender perspective makes a difference. So, for example, in laws of inheritance, from as long as I can remember, women have been fighting for their inheritance. And courts are always deciding cases in favor of women. So you have this constant, set of litigation coming where women seek their inheritance, which they feel they've been wrongly deprived of, and the courts reinforcing this basic right, saying that they cannot be deprived of their inheritance. And as I think about it now, for me, this is now no longer a court-related issue. It's an enforcement issue. It is something that has to be thought of at the government side. The executive has to think about how do we ensure that women are not deprived of their inheritance. Because as a court, I can just give a judgment and say she's entitled to her inheritance. But that enforcement, that implementation is something that has to take place. And so there is a gap. And that gap has to be filled in. And someone has to pay attention to this gap to fill it in. Another example is, for example, domestic violence. Domestic violence is an offense in Pakistan, but would you believe there are no cases on domestic violence? They just don't come to court. So to say that the law is not favoring the women would be incorrect. The law is there, but nobody wants to enforce that law. Nobody wants to use that law. So then you have, again, an awareness problem, a mindset problem. So you have to then work with these problems, and that is, again, something I would place in the executive's domain and say that the more awareness you create, the more important it is. And that would go in any area. So you can look at trafficking, you can look at property disputes. You have to create awareness. So I would say that that's something that we need to work on, is the mindset and the awareness.
Okay. So talking about mindsets and awareness, I think, as you mentioned, judicial decisions also contribute to generating awareness and changing mindsets. So let's move on now to talk about a few of your judgments, and then we'll come back to some of these issues. So the first judgment that I really want to talk about, I think, is probably the judgment, I hope I'm right to say, you're most famous for, okay, because you banned the two-finger test, and this is a Sadaf Aziz case. And it was a bold move at that time. It was, and speaking, I mean, as a woman judge coming out and speaking about this issue was added another dimension to it. So tell us a little bit about that, the build-up, the decision, what were you hoping for, what you think it has achieved, all of that.
So the Sadaf Aziz case was a petition filed by a series of different women from different spheres, basically saying that for rape victims, this two-finger test that takes place, this is unconstitutional, and this does not in any way help in ascertaining whether the crime of rape took place. The case was heard at length, and one of the things that really came out very loud and clear to me was that we are so tuned to the way things happen that we stop questioning them. We just sort of follow the system the way it's taking us. And this is what the two-finger test did. This is, so when I looked into it and when I questioned people, even the female doctors, even the female judges, they all subscribed to the two-finger test. And when asked that why and how they felt that the two-finger test established anything, nobody could really answer it. Interestingly, they were following some jurisprudence based out of what's called Moody's jurisprudence on medical jurisprudence. And even he had revised his book and revised his thinking and had said that this test is outdated, but we continue to follow it. The government stance was interesting. They immediately came with an ordinance and said, you don't need to now pass a ruling on this because we've passed an ordinance and the ordinance will take care of everything. But I said that no, this is more than just an ordinance. We're going to look at this issue and try and understand what's going on. So ultimately, the judgment said that this is against the dignity and the right of privacy of women, and that medically and scientifically it proves nothing. It's a useless test. And so it also gave directions to change the format in which information is taken. Because imagine a rape victim who's married, who has children, how does the two-finger test help? And again, what was alarming was to hear the system tell me that this is the way it's done. Nobody had really thought about it. Even the women hadn't thought about it. And that's what I found to be very alarming, that in a day of DNA testing and whatnot, we're still looking at a two-finger test, and every judgment is referring to the two-finger test and how the two-finger test establishes the crime of rape and not. And as a woman, I feel it even more at a personal level, because I'm thinking that, I'm married, I have children, what does that mean for me? So that's again, this case for me at a personal level is important, because it once again reaffirms the fact that the gender perspective is just missing from the system. And women in the system don't really think as women. They just think the way they're told to think. And that's what has to change.
So yeah, absolutely. This deserves a big hand. But listening to you just now made me think of two things. First of all, it's interesting to note that just as you can have allies in men, you can also have, enemies is the right word, or antagonists in women. So it's women themselves who are perpetrating a test which is anti-women. So I think that's also a way of opening up gender, that gender is sort of, all issues are not gender aligned. There's a crossover. So did you find a lot of women also pushing back and saying that you're going against tradition?
Of course, like I said, the system is going in one direction and you're questioning that. So that obviously unnerves everybody as to why you're questioning it. But the point is that someone has to question it. And then you're not really questioning anything that's illogical or that's not correct. It's the right thing to question. And that's what my job is. I look at the law, I look at how the law is implemented. And if a law is being implemented in a manner that is prejudicing the rights of women and is not even giving them the relief that they're entitled to, then I should be questioning it. And I think that's what, that judgment was an awakening for me to see how entrenched the given thinking process is, and what a big fight this is going to be and what a challenge this is. But I'm very hopeful about it, because I think building the new narrative is something that we're all going to do together, and initiatives like this help to take that message forward so that people can work towards building a new narrative.
So the other thing I was remembering as I was listening to you about the two-finger test was the famous Mukhtar Mai case, which Justice Saqib Nisar had decided. I was still in Pakistan at the time. I'd written an op-ed quoting him. I didn't mind that he was the Chief Justice of the Supreme Court, but it upset me so much because he, in his judgment, said two things which were very upsetting. First, that it's not a big deal. I mean, I'm paraphrasing badly, guys. If you really care about the judgment, please look for it. But the upshot was that it's not a big deal if a married woman is raped. That a woman who has been married and divorced shouldn't feel bad about being examined for rape offense. That was one thing that he said. The second thing, which was even more upsetting, was he said there was not enough evidence to go after the policeman or whatever. So, I mean, it's not in front of you, and we don't want to be revisionist, but I mean, is this the kind of mindset that you're up with?
This is most certainly the mindset, and this is why having more women in the judiciary is important. Having women lawyers is important, because it's not just now about my way of thinking. I'm also very conscious of the language that I use in my judgments. So I try and be neutral in my judgments. So, I advocate for that in my training when I train judges, that stop saying policeman, say police person. Stop saying ombudsman, say ombudsperson. Because you want to encourage and the use of words which do not perpetuate the same thinking. It's not about the men anymore. So we are there, and we're there to stay, and we're there to, you know, increase our numbers. And so we have to, there has to be a new vocabulary, there has to be a new way of writing things. And more importantly, when judges write judgments, they're writing stories. So the question that I ask myself is, whose story am I telling? Is it the woman's story or is it the man's story? If I'm telling the woman's story, then I must narrate her story. And in gender-based violence cases, in her story, what is important will be the violence against her, what has happened to her. Whereas maybe from someone else's point of view, the story will be about why she was where she was, why she was wearing what she was wearing, and whether she asked for it or not. So there is a difference. And whose story am I telling? If I'm telling a woman's story, then I will narrate the story from the woman's point of view. And you have to know the woman's point of view. You have to understand her point of view to give her the relief that she needs and that she is entitled to.
Absolutely. I think that's a really, really important point. But moving on from these sort of slightly depressing conversation to another judgment that I came across in which you have highlighted the role that women can play was the Sindh government versus Sajda Heather, in which you ensured that women were also represented on flood relief committees. What was your rationale behind that insistence?
So devastating floods. So much destruction was brought about. But one of the factors that kept coming out was the fact that, you know, relief is not provided for in the manner it should have been provided for, especially for women. It is a fact that women are badly affected by disasters. Because they're not self-contained, they may lose family and their supporting members, their caregivers, so they just lose everything, and they may not be able to take care of themselves the way a man may be able to go out and take care of himself. So this is one important aspect. Then from women's hygiene to women's medical attention to safety, everything has to be thought through. And so what we found was that there were these citizens committees that had a whole lot of people in them, but no women. And so the judgment requires that there are women in them. There are also people with special abilities in these committees, so that the committees can look at the issues from their point of view and ensure that relief is provided to the communities that require relief in the way that it is required. And interestingly, the law requires that there are women on these committees, but they're not really appointed there. So these citizens committees were made in Sindh to help the government sort of understand what relief is required, where it is required. And I think having women on the committee helps two things. One, to provide relief to women in the manner that they're required, but women also play a role in community building and restoration. So you can use these women, because they are caregivers in their homes, you can use them to help rebuild the community. And you can see what they're willing to do and how much they're willing to do, and you can rehabilitate them as well, give them, you know, purpose, give them things to do so that they understand their role better. It's a community effort, and please remember that Pakistan has 49% population of women, so that's half the population, and you can't just keep half the population on one side and say we'll take care of everything. The we has to include the 49% now.
But do you find that there's some resistance from the women themselves? I mean, I noticed that you said that women are not included. The law provides for women to be included, but the women are not.
Well, they're not the ones who are appointing them, so no. It's the people, it's the decision makers, the people who are appointing them. They are the ones who have to ensure that the women are there.
Okay, that's a really important point to take away, because in a lot of these discussions, it said, I've heard this, and I'm sure you have, that, well, why don't the women put themselves forward? And it's not just enough to put yourself forward.
No, it's not enough.
Yeah. But you've not just focused on women. I think you've also expanded your understanding as a female to include children as well, and the well-being of children. I think one of the cases that I was looking at was Raja Uwais versus Nazia Jabin, in which you were saying that a woman has the right to the custody of her children despite having remarried, because that's always often used as a sort of a weapon against women. So tell us a little bit about that case. What was the husband saying, or the former husband, and how were you countering him?
So this was a case in which a man had remarried, and his children were living with his wife. and he wanted custody of his children, and the reason for custody was that she had also remarried, and therefore he said she had lost the right to keep her children because she had remarried a second time. So the judgment essentially looked at previous judgments and regurgitated what judgments have said till now, that remarriage for a woman does not necessarily bar her right to custody. But I went a little further because I would again say the gender perspective. I talked about custody and talked about custody and for whom are we discussing the issue of custody. And so the judgment says that custody is not about the parents. It has nothing to do with the parents. Custody is about the child. Custody is about who's going to take care of that child, in which environment that child has to be taken care of, where does the child want to live, and more importantly, where is the child going to be safe and secure, where is the child's mental well-being going to be, emotional well-being going to be. It's not just about the finances, that who's going to take care of the child financially. It's much more. So what is that environment in which the child wants to be? The judgment also says, which is what is in the law, but it sort of reinforces it and makes it clear, that a child who can intelligently give their preference, that preference should be strongly considered by the court. In this case, the child was 12 years old, and the child was very categoric. 12 years old, 14 years, 15 years, I think there were 4 children. So they were all very categoric as to where they wanted to be. What was interesting was also that while we were hearing the case, the father sort of became a little offensive. So it gave me again the opportunity to point out to him that this kind of language and putting the mother down doesn't help anybody. It doesn't really even help the custody issue. It doesn't create good citizens. It will just create a culture in which children will grow up not liking him and thinking, it's not nice. So you often find that in these cases, but in these petitions, fathers are saying, I want a DNA test done because I don't think they're my children. And for me, from my point of view, I think it's an awful thing to say, because you're creating a whole narrative where you're pushing out this younger generation and saying, you're possibly not my child. You're putting all these wrong ideas in their heads, negative ideas, and it's not going to help in society building. It's not going to help build a good, strong society. We have to look at things which will help cohesion, which will help bring us together. And family matters are sensitive matters. Family matters are important matters, and custody is really all about the well-being of the child. So this is what the judgment does. It really reinforces something with a new sort of angle to it.
So, says a stereotype attached with women that they will be better at what are women issues. And I was, in fact, recently there's this platform in Pakistan, Reimagining Pakistan, and I had an argument on Twitter, as we all do, about why there's women only on women-centric issues. But Justice Ayesha, of course, doesn't subscribe to any stereotypes, and she is not only deciding women's issues, but also stepping into other domains. And the next couple of cases I want to talk about are non-gender, but other domains in which her expertise shines just as brightly. So the first case we want to talk about is the Al Baraka Bank case, in which you came up with a novel solution to support farmers who were not being paid by the mills because the mills had mortgaged or created a charge in favor of the banks.
That's right.
So tell us a little bit about that case.
So when I became a judge of the High Court, I saw that on a regular basis we got petitions from farmers saying that I've sold the cane to this mill, but I'm not being paid my money. And when I say regular, it means on a daily basis you had 3-4 such cases, and we were constantly giving directions to what's called the cane commissioner to say, please ensure that they get their money. But as these cases moved on, I thought that surely there has to be a better way of doing so. And ultimately, when a case came before me, I said that the cane commissioner can recover the money from the mills by selling off the sugar bags that they have, or by attaching the property. They have that power under the Land Revenue Act. That then led to a new controversy because he started doing that, and the mills came back and the banks came back to challenge what he did, because they said this is all mortgaged and pledged property, he cannot touch it. So that's when this whole case came about. And as I was mentioning to Amber, when I thought about it, I drew a Venn diagram in my mind. I thought farmers' rights, mills' rights, banks' rights. So what's this gray area in the middle? What am I going to do with this gray area? Interestingly, the law doesn't really help the farmer, because the law says that the farmer has to sell the cane to a specified mill at a specified price at a specified time. But it doesn't say that the mill has to pay money immediately to the cane grower. It doesn't say that at all. So I had to think of a way to fill in this gap to ensure that the cane grower got the money, because otherwise, in the case before me, the debt of the cane growers was far greater than the debt, than the entire value of the mill and the mortgage and the pledge. So there was no way that the cane growers were ever going to get their money. So the judgment basically says that when the cane grower sells cane to the mill owner, the mill gives the cane grower a little receipt which says this is how much sugar he sold, this is how much it weighs, this is how much money it is worth, this is the date, and so on. So I said that that becomes the cane grower's retention of title in the sugar. Now the sugar can continue moving from sugar and ultimately become a lollipop in some shop, but that title will be retained in that lollipop, and so the cane grower is ensured that they will be paid first. The banks, of course, were not happy because they thought I had just totally rewritten the law on pledge, which is not what I had done. I had simply secured the right of the farmer to ensure that they get their money first. And it also told the bank that they had to rethink the way they do their business. That is, if they're going to continuously give loans to the banks, to the mill owners to keep buying sugar, they should ensure that the money is paid off to the cane grower as well. And I'm happy to say the judgment was upheld by the Supreme Court, and now we don't get those kind of petitions on a regular basis. So surely somewhere along the line something has happened and the system is working in favor of the grower.
I think what this judgment suggests to me is that you can stay within the confines of the law and still adopt a humane approach. It doesn't have to be so blind that you're not aware of the impact of your judgment. So I think that's, again, I'm going to say, as a female, that's the gender helps inform that humanity.
I think for me, what was interesting was this was a way, like an artist, you get to be creative. You get to sort of think about the law, and you know so much about how the law has to work. You read so much, but you have to kind of like start painting that picture. And for me, this is one of those judgments that I worked hard on. I thought a lot about, and it's that ability to create something, to say that, okay, this is how we're going to do it. So yes, you can go out and discourse it and say it's good, it's bad, but as far as I'm concerned, I interpreted the law to work in favor of a group that was not being paid off.
Absolutely. And how can we have a discussion about Justice Ayesha's judgments without talking about the LPG Association case? And you might think, why is that so important? Because I was writing a PhD on competition law, and in every third sentence, I would say, oh, but these cases are pending in Pakistan, have not been decided for 10 years. And just as my work is finished, she passes a judgment and decides the cases. So I had to rewrite some of that. So let's talk a little bit about that. What I want to, what I'm very interested, I mean, there's a lot of, we can have a big discussion on it. But for today, I'm very curious about what motivated you to pick up a petition that had really been pending for 10 years. I mean, people had been shying away from it. Competition is considered a very technical subject. Even though the petitions were on constitutional grounds, judges were uncomfortable about touching it. You decided a petition that actually decided a fate of more than 100 cases that had been pending in the Lahore High Court. And you also moved the dial forward on the law, and they're now, I believe, they're in the Supreme Court. So tell us about delays, which our system is, of course, riddled by, and you have experienced firsthand, and how judges can, reduce delays, because you certainly stepped in and did that. So tell us a little bit about that.
So these petitions were pending since I think 2009, and they were appeals pending in the High Court. By the time they came into my docket, it was I think 2018 or 2019. And so I'm one of those judges that kind of keeps an eye on my cases. I look at my cause list, and I look at the age of the cases, and cases which are very old, I give them attention in the High Court. So I pay attention to them. I don't give long dates. I try my best that the matter ends quickly. This was an important case because a lot of money in terms of penalty that had been imposed by the Commission was stuck up. A lot of people were looking at those cases because the Competition Commission had virtually become ineffective because of the pendency of those cases. So we heard them on a day-to-day basis, and I think it's important to know that, so you are hearing your regular set of cases, and then we would convene as a bench after 12 o'clock and then hear those cases 2-3 hours every single day. And when you become involved in a case with so many complications, then you're constantly thinking about that case and you're reading yourself. I do a lot of my own research. You read about it, you're looking for information. The lawyers were helpful in providing a lot of material. We had a lot of people come in to offer assistance as well. So it became important. I mean, I think I believe in institutions, I believe in regulatory systems, and that's one area of law that interests me. So I like to see effective regulators, because I think systems work when you have effective regulators. And so that was the objective. We were a 3-member bench, and we took the summer to write the judgment, and then out it came.
And it's ongoing saga because it's now in the Supreme Court. But hopefully, well, let's see. It will be upheld, as all her judgments are, but we'll see how that goes. I think just sort of there's one more judgment I want to talk about, and that will lead us into another interesting area. But you recently looked at the Land Acquisition Act in the government of Pakistan, Zakia Begum, in which you mentioned that this law was a relic of a colonial era. And the topic that is increasingly important in academia in the UK, and I certainly talk about it as well, is decolonization of the laws. So how do you see that judgment as are you supporting the decolonization charge? What are your views? How do you?
This is a big problem. Acquisition is an issue in Pakistan. Land is acquired for different projects, and the biggest issue is the compensation that has to be paid. And in the Supreme Court, you obviously get to see the way acquisition works out in the different provinces. And so in this case, what we saw was, as we saw in other cases that we were hearing at the same time, is that good land is acquired and very little amount is offered in terms of compensation. And again, this is a judgment that goes back to look at the rights of the farmers, to see not just farmers but the landowners, the rights of the landowners, and how they are best treated under the law and the legal framework. And so one of the things that the judgment does is that it goes back in time to see how the land acquisition law came about. And it says that this is a colonial law which came about at a time when roads and bridges had to be made. And so the idea at that time was to acquire land at the minimum cost to build infrastructure. And the judgment says that the same mindset continues even today. Once we have the infrastructure, we still want to acquire land at the least price, as if to say land acquired for public works means and justifies the fact that you will not pay the landowner the value of the land. So the judgment sort of grinds the rights of the landowner as fundamental rights in property and says that they are entitled to the market value and potential value of the land. It also says that valuing land based on land revenue systems is not relevant. So just because the land is not well irrigated doesn't mean you can reduce the price of the compensation. This, I think, will go a long way in securing the rights of landowners. It will also, importantly, give the government a reason to think about land acquisition in future, because it now will not be easy to sort of give little amount of money to the landowners. They'll have to pay the proper price for the land, which means they'll have to think about what land they're acquiring, where they're acquiring it, and how they're going to pay landowners. The judgment talks a lot about how land, even if it's acquired, the landowner must be given the value of that land. And that's what is important, because you're forcibly acquiring land from somebody. Their whole life depends on that land, their future depends on that land. You can't just give them pennies worth based on some old notion of, just this is in public interest. And subsequent to the issuing of that judgment, several cases were decided on the basis of that judgment. And well, the government wasn't very excited by that idea because it meant that they had to pay a lot of money. And as I was telling someone that it's not, the difference for the landowner is not just a small amount. It is a life turning difference. We're talking thousands and thousands of rupees worth of difference. So where land was valued at 4,000 or 5,000 rupees, I don't know what that would amount in conversion, but now we're talking 50,000, 60,000 per canal, per marla, as the value of the land. So that's a big difference. And I think, again, it's a judgment that's going to go a long way in securing the rights of landowners.
So I think what I'm also hearing is that you're saying that laws should be responsive to the situation, the present situation, rather than responding to an old idea. And I think that's something we can all keep in mind. But we also have a young audience in front of us, and I'm sure they're as inspired listening to you as I am. And we want to understand how we in academia, whether as lecturers or as students, how can we support the judiciary in the work of lawmaking? I'm sorry, we are not interested in supporting the judiciary by talking about politics and rule of law, which are bigger issues. But today we are saying, how can we support creative, as you said, creative judicial lawmaking? What advice would you have for us?
So I won't say this is advice to help judicial lawmaking, but I think it's about what your role is as individuals, as citizens, as a community. And the advice I give to all young people is that you need to write. You need to learn to build discourse. You need to learn to how to build a debate in a positive way. So it's important to write about things, write about views, because the world is not about what I think, it's really about what you want. It's your world now, it's your tomorrow. And what's important to you is what you should be thinking about, and what you should be working towards, and what you should be writing about. And I believe there is a difference between my generation and your generation. You don't have many of the sort of mindsets that my generation had that works as barriers. You don't see many of the things that we used to see and which held us back. You're more enabling, you're more tolerant, you're more facilitative. So use all of that. But writing is very important. Opinion making is very important. Deliberate and have discourse, very important. There's a difference between discourse and criticism. There's a difference between healthy deliberation and conversation and negative conversation. So, work towards shaping your future. Take interest in what happens, have opinions, and write about it. I was telling Amber that, don't stop writing now, write more books. Because when I'm writing, I want to see how experiences in South Asia, what does it mean to be, how laws work in South Asia? What are the responses to laws in South Asia? I don't want to always have to borrow the version of the developed world. And so the more you write and the more you think and the more you analyze, whether it's policy, whether it's law, whether it's social behavior, it's all working towards cohesion. And I think that's what's important. So think about your legacy, think about your role, and know that every person matters. Every person, every voice matters, and each and every one of you should have an opinion on something, and you should be writing about it.
So I'm smiling because you said to them, think about your legacy, and I was thinking, well, what is Justice Malik's legacy? What would she like her legacy to be? So I felt she read my mind. But let's end with that then. We would love to hear, project yourself in the future, please, for us, and tell us what you would like your legacy to be as a woman, as a first female judge of the Pakistan Supreme Court, as a human.
I don't really know, but I think what I want is to leave impact, leave footprint. When I was a young lawyer arguing cases, often you would hear lawyers refer to judges and their judgments in a very esteemed way, respectfully saying, very bright judge, very good judgment. And I would like to think when I'm no longer around 50 years from now, 60 years from now, that's how I'm remembered in a courtroom. I want to know that I've left some imprint on the system and that people will remember that there once was a Justice Ayesha.
I think we can all agree to that. Thank you very much, Ayesha, for this fascinating conversation. Even though I thought I knew the answers, I've still learned something new. I think it's now time to take some questions from the audience. In the spirit of gender equality, we will start with women. And also, we would love to hear from students rather than from non-students. Can I just say, if you, I can see hands, I will call upon you, please raise them. But can you just introduce yourself and ask a short question? Please don't make comments or observations. Can we begin with the lady here, the first one here? Yes.
I think you need to use the mic so I can hear you.
Just say your name and what year you are and which university if you're not at the LSE.
So I'm a student of politics and I'm from SOAS and I'm doing my second year undergrad. My question is that right now, although we are very happy for Justice Ayesha to be represented in the Supreme Court, the representation in the higher courts is very low. I was just looking at the websites and I got the number, there out of 106 high court judges, only 4 are women. That's less than 4% of representation. So my question was what we as women citizens can do from different fields to create this pressure on the higher superior judiciary to appoint more women, because although Justice Gulzar appointed you, he also appointed 11 judges in High Court and not one of them was a woman. Thank you.
So you're very correct. The representation of women is very low in the higher judiciary. When I was appointed to the High Court, I was the only judge in the Lahore High Court after more than 20 some years. At the moment, there are 5 judges in the High Court, so 1 in each High Court and 1 in the Supreme Court. I think the most important thing is that women should be considered for appointment. At the moment, I would say that they're not really considered for appointment. If there have to be 10 judges appointed or 12 judges appointed, the ratio that generally comes across is that they'll appoint 1 woman and the rest all men, which frankly I don't understand. Why 1? Why not 3 women? Why not 5 women? You know, I mean, why 1 woman and the rest all men? So it's a mindset issue. It's really a mindset issue. I'm often told there are not enough women, or I'm told, please find us someone like yourself. That's not an answer. When they appoint other judges, they don't look for people like themselves. Why do I have to look for someone like myself? You have to open the door wholly and totally, and allow the women to come through and at least consider them. That would be my starting point. Consider more women, interview the women, make lists, and then really allow women to come forward and see whether they are good on the merit. And that's how you make a first step. So that it is something that we all need to work on. There are not enough women. And even in the district judiciary, so in the Punjab, there are 36 districts. Each district is headed by a district and session judge. And while 35 district and session judges will be men, 1 will be a woman. The best that I was able to nudge and push was to get 2 women and the rest all men. But again, the question is, why just 2? Why 1? Why not 5? Why not 6? Why not 10? So this is something we need to work on. And so write about it, question it. That's what you do. Look at data. We don't even have enough data that's collected on these things. That's also something that we need to do.
Yeah, and be lawyers, be good lawyers so that you're seen and heard. Sorry, we have, let's take one question from this gentleman here and we'll come back to you. Yes.
I really appreciate.
Sorry, say your name, please, and what year you are.
Yep, I'm a doctor from Pakistan. Right now, I'm studying global health policy in Anglia Ruskin University, London.
Okay.
So I want to ask a question from Mrs. Justice Ayesha Malik, that why is there so much delay in our judicial system? Because we see that there are so many land cases. I can give you one short example. That I have a land case, land inherited from my forefathers. First, my grandfather was fighting that case. Then my father was fighting that case. Then I am fighting that case. Unfortunately, my grandfather passed away. Then my father passed away, and now I am fighting that case. Why is that there is so much delay in our because when I recently I saw an example that I have heard in news on the TV that a person who got I guess I don't know, I don't I'm really sorry that I don't exactly remember that case perfectly, but someone got I don't really remember that typical word that someone had a phansi at that time, and he was released after 3 years from Supreme Court, that he was got free from Supreme Court. Why is so that?
So I'll tell you why. It's very simple. We as Pakistanis are highly litigious. We litigate on everything. So one of the biggest reasons for litigation and the delay is just the sheer volume of cases that come to the courts. So for example, hypothetically, if on a weekly basis the court decides 100 cases, you will have 400 new cases coming into the court. Now even deciding 100 cases is a lot, but the 400 new cases just totally neutralize the impact of those 100 cases. The second reason is just delaying tactics. So a lot of adjournments. We take a lot of adjournments, and for all sorts of reasons there are adjournments being sought. And if the courts are not strict about adjournments, then yes, there will be delay. And then the third is a lot of frivolous litigation. Frivolous litigation overburdens the system, and when you overburden the system, then judges spend a lot of time first dealing with frivolous cases before they can get to the real cases. Now, unfortunately, a lot of time is spent by concerned people like yourself that their cases get delayed. But in the system, there are also people who just litigate for the sake of litigating. And we don't talk about that. And you have a system where litigants as well as lawyers use the system for whatever reason, and delay cases and delay the pace at which that case has to go. Now, yes, of course, it is the responsibility of the judge to ensure that the pace of litigation is fast, it's effective, but courts are overburdened with work. And we have to look at that. It's not just a judge issue, it's a society issue. We have to look at that. And I can give you an example. So in the High Court, you'll get a writ petition which will say that I don't have a gas meter. So give them a direction that I should get my gas meter. Then the gas meter is not installed, then they'll come back in contempt and say my gas meter has not been installed. So go and ask them why they haven't installed my gas meter. You'll get a petition saying my bill is wrong. So tell them to correct my bill. You'll get a petition to say I lost my post. Tell them to find my post. So, you'll get a petition to say I didn't get the right number of marks on my exam. I'm just talking about the small issues. These are the petitions you get on a regular basis. As a judge of the High Court, I was hearing up to 80 cases a day. That's a lot of cases that I'm hearing. And that's because on a daily basis, you have a lot of cases coming to court. So one of the problems will be the high number of cases that are coming into the court. You also need a good, effective system of governance. When you have an effective system of governance, then the petitions will stop. So people will stop coming to say, I'm not being paid my salary, I'm not being given my pension. These kind of cases will stop. My gas line has not been installed, my gas meter is not working. These will all stop. So when you have effective governance and you have people paying attention to these issues that are there, the litigation will stop. And when this kind of litigation will sort of zone out, then the more important cases, the real cases which go on forever, they will be attended to.
Okay, lots of questions. This lady here, yes. And please say your name. Nobody's telling me their names, which is very boring. And name, year, where you're studying. Yeah.
I'm Manur. Sorry, can you hear me?
Yeah.
I'm Manur. I was at Oxford and now I'm studying for the bar.
Okay, speak up, Maro. Yeah.
Sorry. My question is, you touched on domestic violence cases and them not actually coming to court. I was wondering, because I feel a lot of people have like a distrust as well.
Sorry, I can't hear you.
A lot of people have like a distrust.
Distrust.
I don't know where that stems from. Like maybe it's a thought that perhaps like their sort of family issues will be aired out in public. But I was wondering, what can like the legal field do to help alleviate that distrust?
So it's not a distrust. It's a mindset. It's a cultural issue. It's traditional issues. It's the way families think. If you want those barriers to be broken, then you have to change it, and you have to create awareness, and you have to talk about things. So again, I go back to it, you have to help build a narrative that brings down these cultural barriers in a way that is comforting for everybody. You're not supposed to just break it down and say, this is the new way of doing things. That's not what it's about. It's about enabling people, those people for those whom it is important, who want to fight this battle, they have that opportunity. The courts are there, the system is there, but you have to create that awareness. You have to make people understand that it's okay to do it if it is done. So that's your role. I keep saying, I go back to it. Anything you'll ask me, I'll tell you, write about it, make opinions, create awareness.
Okay, can we have a question from this side of the room? Raza, not you yet. Can we have this gentleman here in the black sweater? Yeah.
Yes, my name is Varis. I'm doing a master's at Queen Mary. So, as you just talked about the delaying tactics, so Justice Mansoor Ali Shah, he was also here last year. So, could you talk about what's being done about the efficiency of cases in Pakistan? Because the rule of law is an important institutional factor that contributes to the foreign direct investment, which can contribute towards economic growth, which is an important topic these days.
Right. So a lot is being done. Justice Mansoor and I sit on a bench together, and we impose a lot of cost on frivolous litigation. Recently, we imposed 500,000 on the CDA for bringing a frivolous case to court, a case which should not have come up to the Supreme Court. And the judgment talks about how institutions and departments make mistakes, and then they want to correct their mistakes by burdening the court and requiring the court to fix their mistakes. So one way to do it is by imposing costs. I also sit on another bench, on bench one with the Chief Justice, where we are very strict with adjournments. So an effort is being made to be strict with adjournments, to start imposing costs. But this is not something that's going to go away in one day. It'll take time. We have a case management plan, but we have to be more scientific about our case management plan. Not everyone is sold to the idea of technology and case management, so we have to work on creating awareness for that. In my time in the High Court, I've actually toured London, Scotland, the US. I've been to Thailand and some other countries to actually see how they control the pace of litigation. There are lots of wonderful ideas out there, but you have to have the system believing that these things will work. It can't just be one person's desire, because then the system doesn't work when one person wants it and nobody else is willing to follow it. So I think what's important is that we talk about technology, we talk about case management. This is the way to manage cases. We also talk about not bringing frivolous cases to court. We also talk about not adjourning cases unnecessarily. We've recently, amendments have been made in the procedural codes to combat these problems, but this will take time.
Okay, there are a lot of questions, so what I'm going to do is take 2 or 3 and then let Justice Ayesha answer them, please. So the lady in the blue
You
jacket.
want me to remember them?
I'll try to remember
Okay.
them. Or should it?
Take.
The lady in blue. Okay, we'll take one question and quick questions and quick answers. We
Hello,
give
ma'am.
everybody.
It's an honor to have you with us. My name is Ayman Masood. I'm a policy and development graduate from SOAS. My question is a little controversial, but I really want to ask you, what do you think about the blasphemy laws in Pakistan? Don't you think they're used as a weapon against minorities in our country?
That's not really a judicial question to answer. But you see, there are many laws that are used in the wrong way, or that are used in a manner that can endanger groups. So I don't think really it matters what I think. What matters is what you think. And if you think that there's something should be done about it, then as someone who's studying policy making, you should write about it.
Good answer, I think. Can we have a question here? Cambridge University jacket in LSE. How? Why? Please ask the question.
My university funds it.
Okay.
Justice Ayesha Malik. I'm Jaideep Singh Lali and I'm studying law at Cambridge. Having worked with the current Chief Justice of India and one of only 2 female Supreme Court justices in the Supreme Court of Nepal, I've educated myself quite a lot on the gender perspective. And I was wondering if taking cue from your reliance on international law in Raja Awais v. Nazir Jabin, we could expect you to expand your gender perspective to issues of sexual orientation and perhaps get your views on if a case comes to the Pakistan Supreme Court on the constitutionality of sodomy laws.
So
If you
this
would-
is something that judges don't talk about unless the issue is before them, because then you would have already given your mind to an issue. So when cases come before the court, we talk about the court. But so far as gender perspective and all, I train judges in Nepal, in Indonesia. I work with an institute that trains judges in these different parts of the world on the gender perspective, and I work with judges, and it's interesting to see how there is this commonality in the problem. And in fact, just before my appointment to the Supreme Court, I think India also appointed 4 women to the Supreme Court just at that time. So it shows you, there's a common element within this region, and we should all work on it. Although Pakistan was one of the last countries to appoint a woman to the Supreme Court, nonetheless, there are not enough women there. So you all sort of need to buckle up and start talking about it.
Okay. Yeah. The gentleman with the scarf, yes.
Right, ma'am. Syed Haris from City University, London.
You have a microphone, yeah.
Hello, ma'am. It's an honor. Syed Haris Hassan. I'm doing my LLM from the City University of London in banking. So we've talked about women and how they face problems. I want to ask you a question about another marginalized portion of lawyers that are first generation lawyers. So what's your suggestions for them? Because we as first generation lawyers have, half the opportunities that, people from legal family have.
Before you, I was just going to say, she's a first generation
I'm a
and a
first
female. I'm a first generation and a female. We've survived.
The world is your oyster. Please do it the way you want. In fact, it's better to be first generation. You're not bound by any of the conforms of, what the others before you did. Because often second and third generation lawyers will, tell their children, this is what we did in my time. This is how you should do the work. So you don't have any of those issues. So please go ahead.
Although we used to joke and say we need a father in the profession, but we've survived. Okay, this side, the off-white sweater. Am I recognizing the color correctly? Yes, you. Yeah.
Unless you can be loud. All right.
Project your voice, as we lawyers would say. Project your voice. Say your name and where you're from, and yeah.
Hi, my name is Anamta Rahman. I'm a trainee solicitor in-house at a gaming company called Activision Blizzard. Lots of interesting competition things to talk about on that level. But a question, well, for both of you, and it's an honor to be in the same room as you guys. But with an increase of extremism and terrorism in our country and some of our neighboring countries, what are your concerns in terms of the development we have been able to make for women in our professional environment? And then how do you see that change as this kind of extremism and terrorism increases in our country?
Yeah, I mean, you can speak about that a lot because you had that protection of women judges. Yeah, for her.
So I think there are 2 different things. Terrorism and intolerance are different things. What I would focus on and what I focus on more is the internal working environment. So you have to first make the environment conducive for women. And the first challenge will be the cultural and traditional roles seen for women. That starts at home. So that's really a you thing. All of you have to work on that because it's difficult for women to step out of the house. The problem is that once she stepped out of the house, how does society perceive her? I get a lot of people asking me questions like, do you do easy cases? Do you do family cases? Do you come home at 2 o'clock? And the answer is no, no, and definitely not. But I raised my children as a lawyer, as a judge. I now live in Islamabad. My family lives in Lahore. I try my best to balance my life. And I think following role models and mentors is one of the ways that we will help eliminate these problems. These are problems that intensify and they gain momentum because there's no other narrative going out there. Until and unless you don't sort of bring out that narrative and you don't assert that narrative, it's not going to change. I think that when you actually go to Pakistan and you see how things are, it's very different from what you think it is. I don't think I've ever felt discriminated. I've never felt that I've been mistreated in the profession, in the courtroom. I've been the only woman in a courtroom many, many times. I've been pregnant throughout this time. I've worked throughout my pregnancies. I found the system to be helpful. I found that my colleagues are helpful and they're understanding, and they give me space and they give me room, and they try and understand what my needs are. So the question, as you put it, I would say, I wouldn't attach those things necessarily with how to empower the women and how to ensure more women get the opportunity to do what they want to do. It's not about just working. It's about being able to be who you want to be. And to do that, you just have to, again, build a narrative that is tolerant to those views and allow people to live the life they want to live. And that doesn't necessarily mean crushing tradition and culture. I respect my culture and my traditions tremendously. I abide by them. I hope I'm a good daughter-in-law. And I try and do all the things I'm required to do, not because I have to, but because I want to. I subscribe to that. And that's what it's all about. It's about learning to balance. It's learning to do things in a way that works for everyone.
Okay, I think we've had a question here. This side, she's not even raising her hand anymore, but go ahead. Okay, Raza, yeah.
Hi, I'm Raza. I am a lawyer, and I also founded this conference 7 years ago, so thank you everyone for coming for the 6th edition. My question is based on legacies, because we've talked about legacies, and within the law we have legal doctrines like the doctrine of necessity, which is sort of a bad legacy. In terms of the law, I think doctrine can be good legacies as well. So for instance, when will the apex court set across clear principles to govern whether a petition is maintainable? And if we have that, maybe we can deal with frivolous cases at the district courts.
So I would say that the apex court has laid down the guidelines and has repeatedly done it. There's a difference between what is laid down and said and what is enforced. And I've said before also, a lot of it now is an enforcement issue. It's an implementation issue. Whether that is followed or not is the question. And please remember, the judge doesn't bring the case to the court, the lawyer does. So this is a question to ask your own community, is when will they stop bringing the frivolous cases to the court?
Okay, yes, you, please. We have time for about 3 more questions. So if yours is a really pressing question, raise your hand high.
Assalamu alaikum. Thank you very much. My name is Hatim. I'm studying computer science at the City University of London. And I am the oldest and only brother to 8 amazing sisters, and they all live in Pakistan. And I get the issues. Of course, they live in a society where they are only recognized, where women are only recognized for their looks, or, you know, you have contests like Miss Universe, and rather it's for them to build in their confidence and to basically aspire to what they want to do in life. But I did have a judicial question. Basically, from the outside looking in, I see people of power who have control, or the elites, who, in a sense, swerve away from the law. So, for example, a politician who has cases pending in corruption end up being a figure in the government, and the cases get dismissed. There's other examples like Shahrukh Jatai, Abdul Majid Ashakzai, even Raymond Davis, for example. What would you like to comment on that? Thank you.
So these are problems, and these are problems that have to be dealt with. But really, I mean, I can't really say that these are judicial problems or judicial issues. These are problems of society, of the way we deal with money and power and how we understand it. And as a country that's still growing, 75 years, I believe this is the time for people to reflect upon what their priorities are and what is important, which is why I throw it back at you, the youth. You shape your tomorrow, and if your tomorrow is not about money and power and this, then change it. Then change it, play a role. I think just like the gender perspective, the youth perspective is equally important. The youth's opinion is equally important, and the youth's vision of its tomorrow is just as important. And I think it's important for the youth to voice these things, because ultimately, what matters is the world that you are going to take and live in, and the world that you want to live in. And so things that are not important and are not relevant and things that have no meaning in the world that you want to live in, you should be able to say so. And so the more you speak up about it, the more people of my generation will start looking at these things. I think it's vital. It's vital. That's what public participation is all about. So you need a youth perspective as well. You need the youth to speak up on issues that are important, and they need to show the way that they want. You know, what is the vision that they have for the future? Because you are the future.
Okay, last 3 questions. I'm looking for the highest.
Oh, this little one, ask the little one.
Oh, yes. First, your question and then 3 more. Yeah, go on.
Temur, his name is Temur, and he's my nephew.
Okay. Hello, Temur. I have a nephew called Temur as well. Clearly a popular name in nephews. Yes, go on.
Hello. My name is Timo, and I am still going to Thomas Kennington Preparatory School. My question is, if you had to make one change to the judicial system in Pakistan, what would it be?
Oh my God.
Excellent question. Yay. Just one.
I would, oh my God, there's so many things.
Pick one. Now you have to pick one.
I have to pick one. Only one? I think effectiveness, I would try my best to see how to make the system efficient and effective so that it responds to the need of the people. So they've talked about delay, they've talked about the fact that, you know, there are too many cases in the court. So effectiveness. I like to think that I'm a good administrator. So I would like to use my administrative skills to make the system efficient, effective, timely dispensation of cases so that things move in the right direction.
Okay. Do you think that's an effective answer? Okay, great. 3 more questions. One here, white, red, and shall we just give them all to the women? No, we'll give one this. And let's see how that goes. So in that order, yes. Question 1, and then red shirt, and then, yeah, you.
Assalamu alaikum. My name is Mirab Amir. I'm a master's student at the LSE. So, Justice Ayesha, you spoke about furthering the cause of women in Pakistan, and you've done some remarkable work. But I just wanted to ask, in a country like Pakistan, where people like Mumtaz Qadri get a lot of support, where you have things like the grave and sudden provocation plea still being used, are there certain matters that you think, because they're so intertwined with social norms and religious misrepresentation, that there are certain categories in which you simply struggle with furthering the cause of women, or that you feel hesitant, or that you think that there are limitations?
So there are causes that are difficult to deal with. But again, it's really about perspective. It's about how you see things. I like to look at things with a very sort of positive outlook. The challenges before me are big, and there's so many things that have to be looked at. So the focus really is on seeing where you can make a difference, how you can make a difference, and tread those areas first, because those are the places where you'll make a difference. And then help also bring in people into the community. The larger you get, then easier it is to deal with the other problems. And the ones that you talked about, you know, those are again problems that is how society perceives itself, how people see themselves. And I think that this is a question for it's a governance issue. It's a question for the executive to look at. It's also a question for people themselves to think about. I think it's time that people also see what they want to identify with. What are the values that they want to identify with? Because in a democracy, for a democracy to work, it's not just about the fact that you need elections and you need, you know, court systems and all. You need a cohesive society. You need people to learn to work and live together. And one of the things that we as Pakistanis often comment on is that when people travel abroad, they're okay with standing in lines, they're okay with waiting, they do everything in an orderly manner. So it's not that they don't know how to do it, but when they're in their own country, somehow they are willing to overlook all of that. They want to jump the line, they don't want to wait their turn. And so that's what we have to ask ourselves, why do we do that? Why do we do that? Why is that important for us, that in our own country, where we should be looking at our own interests and we should be looking to build our country, why are we willing to look for ways around which benefit us, which benefits me. So it's not really about me, it's not about I, it's about us. We have to look at us as a community, as people, and work towards building our national identity and our national, status as people. We have to build our society together.
It's really important. Red shirt here, please. Your name and your question. You've been waiting a long time.
My name is Neha, and I'm currently doing the bar course at City. Firstly, it's an honor to be in the same room as you are. You inspire many girls who are pursuing a career in law. Your intellectual prowess is great, especially the Sadaf Aziz judgment, which I feel that everyone should have a read at. It's 2021 Pakistan Criminal Law Journal on page 205. Very meticulously dealt with on a very sensitive issue. I have a twofold question. The first question is regarding the amendments of honor killing, the 2016 amendments. And the question is, do you think the amendments, they adequately address the loopholes in the law that were there before, considering the fact that the burden to prove the honor is on the prosecution, and if the perpetrator does not claim that it was done on the pretext of honor, then it can fall under the PPC 302 and then PPC 309
Okay,
can
that's
be
a lot of
ultimately
law.
applied.
Can I just say she doesn't amend laws, right?
Yeah.
That Parliament does that.
But,
Do you have a question? Sorry.
Do you think it addresses the loopholes?
I think I can't really answer that because my job is to interpret the law. And when and if that situation comes before me and I get to interpret these provisions, then I'll have an answer for you. But as of now, I wouldn't really know how to address that issue for you because I don't make the amendments. I just interpret them.
And the second question is, what are your views on the suo motu powers?
Oh dear.
Okay, fair enough. That's a good question. Yeah, finally, that had to be asked. Go on.
So, suo motu powers is not new to Pakistan's jurisprudence. It's been there for a while. And there are two ways of looking at it. One is the suo motu powers that are exercised in political cases, which kind of brings out not the best of what we want to see. But then there are those suo motu cases that have been exercised over time, which have laid down some foundational jurisprudence in the country. So, for example, the bonded labor case. That's a suo motu case where the court took notice of bonded labor, and it's one of the judgments that, given by the Supreme Court to put an end to bonded labor. In the same way, a lot of cases coming out with respect to someone here mentioned minorities and their rights. So when there were riots against minorities, suo motu notice was taken of that. So there are judgments taken on suo motu notice where the court has interfered because something was so perplexing and just so not right that the court felt compelled to take notice of it. At the same time, the problem arises, and your question really is geared when problems arise in the political domain and the court sort of steps in to do its play its constitutional role. So then there's a question of whether the court should do it or should not do it. But in a recent judgment given last year, the court itself regulated the power of suo motu and sort of laid down some guidelines to be followed, where this is a power that the Chief Justice can't on his own exercise, but someone has to refer the matter to him. So it's a way of the court kind of like regulating its own power. The debate hasn't ended yet. It still continues as to whether it should happen or should not happen. But to answer your question, the history of Pakistan's jurisprudence will show that suo motu powers have been exercised for a long time, and in important areas other than political areas where they have done good. Environment is another area where this power has been exercised. So it has happened, and nobody is talking about those cases for some reason.
Can we have our last question? I promised this gentleman, I apologize to all the people whose questions I couldn't take, but आपने पूछे ही इतने ज़्यादा, what can I say? Yes, last question. I think we.
My name is Arbaz and I just graduated with a degree of South Asian Studies from Columbia this semester. So my question is basically about the principle of seniority in the judiciary, especially when it comes to elevating senior judges, as well as when it has to constitute benches for the more important cases. Do you think anything can be done to remove this principle?
Remove the principle, meaning?
Of seniority, of how it's used, especially when, even in your case, when it was used.
So I'll answer it to the extent of my case. So when I was being appointed, and I was being considered to be appointed to the Supreme Court, this debate about the fact that I was not the senior most judge of the Lahore High Court was brought up. I was at number 4 in seniority. And to answer the question, I'll ask a question, that the 3 judges appointed before me were also not the senior most. Out of two of them, one was at number 4 and one was at number 5. They were unanimously appointed. Nobody questioned it. Before that, over 40 or 45 judges have been appointed who have not been the senior most. So to say that there is a seniority principle for appointment would be incorrect, in my opinion. There is no seniority principle. I think the argument is that the appointment of judges to the Supreme Court is not really structured. It's based on a choice. And the question is, whose choice should it be? So should everybody in the commission have a choice? Should the Chief Justice nominate someone and then everybody vote on it? So I think it's more about the exercise of power than it is about seniority. But if you were to ask me as a rule, I would say there's no such rule. The appointment to the Supreme Court is a fresh appointment. I was not the first non-senior most judge to be appointed. There were many before me. So in that context, it's really, one has to wonder what the debate was really about, and whether it was structured at the senior most or whether it was really about the way in which the nominations take place. So I think that's it. So far as constituting benches is concerned, in my 10 years in the High Court, what I've understood is really it's all about the discretion that's exercised by the Chief Justice. So the difference between the Chief Justice and myself would be the administrative powers that the Chief Justice has. And of course, there are ways of doing things, and there is a question that is being asked as to why senior judges are not put on benches. But again, I think this is not a question that I can answer by saying this is the rule and this is the rule that has to be followed. There is a way things are being done. There is a way that it's been done, practiced. And if things have to change, then we look at the future regimes to change it. But as I understand it, really, the Chief Justice has the discretion to administer the court. And it's really about the Chief Justice and how the Chief Justice chooses to administer the court. It's not written in any rules. These are interesting debates because they question the system, they question the way decisions are being made. So the outcome at this stage is difficult for me to answer, but to the extent that there is a debate, I think all debates are, it's good that debates take place because they make the system think about how to be more efficient and effective and how to be more fair in how things are done.
Okay, so with that, I think you must be tired. Lots of questions, and thank you for answering them so patiently. We will close this session. Please join me in giving her, Mrs. Justice Ayesha Malik a very big hand. Thank you. Thank you. And we hand back to the organizers. Yes, can we continue sitting here? Okay.
Thank you, Dr. Darr, and thank you so much, Justice Ayesha. It has been an absolute pleasure to have heard you speak and have hosted you at the LSE this year. On that note, I would also like to thank the rest of our speakers, namely Dr. Raza Bakir, General Harun Aslam, and Michael Kugelman, all of whom traveled to London especially for our conference. I would also like to take this opportunity to thank an individual without whom this conference actually would not have been possible. Last year, I stood in a similar position and said, it may have almost been impossible to do an event without his support, but I think it is with a lot of certainty that I can say that it is indeed impossible to do an event at LSE without his support. Thank you so much to Dr. Nilanjan Sarkar, the Deputy Director of the LSE South Asia Center. who was so kind enough to sit through today's proceedings acting as our academic chair. Just how much help and support he has shown, how much effort he has put in just to ensure that our efforts don't go to waste. I'm extremely grateful to him. As the conference comes to a close, I would now like to thank my team, the LSESU Pakistan Development Society, each and every one of whom has played an integral part in organizing the 6th edition of the LSE Future of Pakistan Conference. I'm going to try and name some of you, or maybe all of you, and I really hope I don't miss any names. But starting with Noor, thank you for dealing with all the unnecessary and minor problems I'd have with literally every poster you'd make. I know you didn't even apply for marketing officer, and yet you put in a tremendous amount of effort in the role. Haseeb, thank you so much for bringing in such a mature perspective to the group. The professionalism and high standard of work that you did often, well, I'd actually say more often than not, on very, very short notice, was just very, very impressive. Asad, yes, Asad, I hope I've got it right this time. You really proved to be an asset on the day. I did not complain about anything, and I'm grateful for the initiative you showed on conference day. Myra, thank you for showing so much interest when at times it seemed to be fading away, taking lead where it was needed, and just carrying yourself in such a professional manner. Your thoughts and ideas played a huge role in shaping this conference, and I am very grateful for all that you've done. Sarah, well, thank you for the work that you have done over the years in both an official and an unofficial capacity. I think it goes without saying that having somebody who can handle pressure situations while remaining as strict as one can be with regards to all the rules and regulations, which sometimes may be unnecessary, but they're rules nonetheless, that LSE and the SU have in place. And thanks to Sarah, we make sure that we follow them and aren't in any trouble. Sufia, well, what can I say really? No complaints, no demands, no requests at all. Very, very cooperative and understanding in every situation. And let's not forget the most important bit, delivering when it mattered the most with sponsorship, without which we literally would not have been able to have hosted this event. Meerab, well, I think apart from the several instances where you showed up even an hour late to meetings, sometimes even more, I would say that the skill set and ideas you brought to the group were simply remarkable. And like I said for Sufia, with sponsorship, when at times we would lose all hope of getting any funding from anywhere really, and possibly not being able to do a conference at all, you kept at it and delivered where it mattered the most. Maruk, first and foremost, I wish I was as organized and on top of my work as you are. For making it to several short notice meetings, dealing with so many logistical tasks at hand, and trying your level best to make the society a bit more organized, which, as far as I was there, I don't think was ever possible. But thank you so much for all that you did. Usman, well, from starting the year by saying that Park Dev was your 5th, or was it your 6th priority in life, to dealing with all the last minute complications, handling speaker logistics, being someone I could trust with anything and everything in the lead up to the event. I am very grateful for all that you've done. I know the society may not have been one of your topmost priorities, and that makes it even more meaningful, I believe, because what you were doing and what you've done was more personal for me as a friend. Zirak, well, what's the fun in Park Dev without Zirak? I think there would have been no Park Dev without Zirak. I think there's a lot I can say here, but I'll try to keep it short. I'm grateful for all that you have done as a friend, as a co-president, and most importantly, as someone who has always tried to have my best interests at heart. This conference would not have been possible without you. And everything you did, including delivering with the much needed last minute sponsorship, and just making sure you were somebody who was there whenever I needed it, I'm very, very grateful for what you've done. And last but not least, I would like to thank Alim and Afzal, both of whom are not officially part of the society, but are two of my closest friends who have pretty much helped me stay sane throughout the last few days. And I think even further than that, over these last 3 very interesting years. You've both been unwavering sources of support and have been two people I've always been able to count on, regardless of what the situation may look like. I think Park Dev or FOP would not have been possible without you. So I joined the Pakistan Development Society in my first year because despite being 1,000 miles away from home, with a new set of opportunities, I wanted to utilize the chances I had to give back to my beloved country as a student at one of the top educational institutions of the world. Pakistan forms the basis of my identity. And I'm not alone in sharing the discontent, annoyance, but I think more importantly, a sense of disappointment when you look at news channels and see the direction in which the country is headed nowadays. But this also begs 2 questions. What is it that we can do? And where do we start? I have personally struggled with this question. And after giving it much thought, I took inspiration from one of the speeches of Quaid-e-Azam Muhammad Ali Jinnah, in which he said, "This is your government. It is quite different from its predecessors. Therefore, appreciate when a good thing is done. Certainly criticize fearlessly when a wrong thing is done. I welcome criticism, but it must be honest and constructive." So we must take responsibility for our actions and try to effect change where we can. But as students, there's only so much you can do. Thus, we speak. And as one of my favorite poets, Faiz Ahmed Faiz, once said, "Bol ke lab azad hain tere." We speak to promote the ideals Jinnah held clear, the ideals we unfortunately have fled away from. We speak for the ones who cannot speak, and we speak against the ones who wish we were silent. At this year's Future of Pakistan conference, we held this quote very close to our heart, as we discussed many of the problems of polarization and what we can do to bridge the gap between different segments of society. Pakistan's problems are multifaceted. It stems from economic instability, but the most important question that needs to be discussed is of our political legitimacy. Therefore, any discourse that you have on Pakistan must cover all aspects of the issue, whether it is a problem of constitutional interpretation, like Justice Ayesha explained, a lack of policy and institutional reform within our economy, like Dr. Raza Bakir touched upon, or the need for enhanced cohesion amongst key state institutions, which Michael Kugelman and General Harun Aslam stressed upon constantly in the first session. I hope you enjoyed the insightful discussions we had and took away the main lesson. The future of Pakistan depends on us, you, me, and all the bright young minds studying right now, hoping to make plausible changes to the country's dynamic and saving the sinking ship. Because you know what? If someone can, it's us. With the promise that the Pakistan Development Society shall never waver in its endeavors for a better Pakistan, I would officially like to close the LSE Future of Pakistan Conference 2023. Thank you all for coming, and Allah Hafiz.